Ed Sheeran demonstrates how copyright is destroying musicians. Copyright cases around music are a great demonstration of many of the problems caused by our approach to intellectual property. Artists are generally inspired by other artists and societal context. Most artists make very little. Some become fabulously wealthy. Artists with few resources must be extremely careful not to infringe the copyright of a powerful artist. Powerful artists have access to legal resources that allow them to, intentionally or unintentionally, take from smaller artists, without facing similar repercussions. There is a complete failure of the system to acknowledge that people produce similar works independently, or that human progress has often been driven by conscious or subconscious inspiration. The current regime would have us paying royalties to the dynasty of the guy that came up with the wheel. I don't think there's any justification that we'd be better off as a society if that were the case.
On top of that, many cases, including this one, aren't even artists suing other artists. They're estates or companies that bought the rights suing. Oftentimes the creators themselves would be aghast at this.
I've only really looked into the case involving Thinking Out Loud and Marvin Gaye's song, Let's Get It On. I'm not music buff, but when you listen to them, they are completely different. There is no similarity at all. Sheeran's claim to the court he was going to quit music struck me as beside the point. I hope the jury didn't hear that, lest it influence their verdict. The question for them was if there was infringement. There obviously wasn't. This meritless lawsuit was always going to fail. But Sheeran was fortunate to have deep pockets. He can afford to defend meritless lawsuits. The bigger issue is how to deal with large companies suing independent artists, and the consequences they should suffer for instituting meritless lawsuits.
The two songs are very similar in some ways, similar enough that even Sheeran played them as a live medley. I think the strongest argument is that the common elements are mostly shared genre markers, and courts have consistently held that genre similarities aren't evidence of copying.
They're similar in terms of tempo, chord progression, chord rhythm, and chord voicing, despite that the second chord is actually subtly different between the two. When you transpose one, you can hear the similarities. But that shouldn't even be close to enough to be infringement. I'm one to think they got Satriani Coldplay wrong as well though. There are just too many examples of songs that make really good mashups. For Non-Blonde's What's Going On and Bobby McFerrin's Don't Worry Be Happy, for instance. I'd say those are more similar than Sheeran Gaye.
The two songs are very similar in some ways. This is a vacuous observation. Any two songs are similar in some ways. Even Sheeran played them as a live medley. I think that says more about Sheeran's skill as a performer than it does about the similarity of the songs.
No, it doesn't. Watch Rick Beato put them side by side. This is not to say it's an infringement. They're just very similar.
Rick Beato did an excellent comparison of them and how they are very similar. However, similarity is a personal judgment, I think.
No one is suing indie artists for the $70,000 they made off of streaming last year.
There's only so many notes and very few chords used in pop music. At the risk of sounding like a grumpy old man, I find very sad the fact that pop songs have become nothing more than 4 chords, just repeating over and over, with a thin veneer of inconsequential melody over them, serving a never-ending stream of banal lyrics. Is this really the best of what award-winning musicians like Sheeran et al. Can do? I mean, they don't even bother changing the harmony for the chorus, and where has the bridge gone?
Oh, I'm right there with you, man. Modern pop is mostly dreadful. I think music producers have homed in on the most appealing chord progression possible, and are reluctant to deviate from it, like an arms race. What boggles my mind, though, is that some people don't seem to get bored by it. To be honest, modern pop isn't even really music anymore. It's much more a multimedia thing, with visuals, hot performers, cool videos, etc., playing a massive part in its appeal.
Always makes me laugh when people put on their modern music is rubbish hat to complain about the axis of awesome progression, which is a slight switch around of what is widely known as the 50s progression or oldies progression, because so many songs from the good old days when music was fresh and vibrant and performers had real talent used it.
When people say that older music was better, they don't mean that all older music is good. There was lots of crappy music in the good old days. The stuff they're talking about is the good part. These days, there's really no good part, at least not pushed by the big music labels. There is some great stuff outside the US, or from independent artists, etc.
My understanding is that facts can't be copyrighted. If there's only so many chord progressions that people find pleasing, and music taste is universal, and we're born with it, wouldn't that make music more fact-based? Everyone will more or less agree on what is a pleasing progression.
We honestly need to rethink intellectual property from top to bottom. It's not just copyright and not just music. It's so much more, and it affects every single kind of IP. Patent trolls, overly broad and vague patents that stifle innovation and prevent competition. Amazon should never have got a patent on one-click purchases, and hardware shouldn't be impossible to enter due to entrenched players' deep patent portfolios. Overextending trademark. Look up all the ways Monster Beverages tries to abuse their Monster trademark, just as one example. Copyright is used to stifle innovation in the arts as seen here. It keeps works out of the public domain for way too long as well. Not only do these directly cause harm, but they create chilling effects due to how they let the legal system be weaponized in their defense. Even if I would win a lawsuit regarding whether I'm allowed to do something, I might still let a big player bully me out of it because of the risk and asymmetric cost of going to court. This generates a huge amount of friction. Without our current IP system, you would not have all these abusive middlemen in publishing, music, or other media. Not only are they stifling new art, they're benefiting from IP by using it, take a huge cut directly from artists per their contracts. Trade secrets, allowing for reverse engineering but not direct espionage. Are IMO the only kind of IP that we should allow ACES? Everything else needs to be thrown out and potentially replaced with something else less abusable. I think Netflix should be allowed to fund a big movie and recoup the costs fairly without it being immediately ripped and given away for free, but they shouldn't get to bully people making similar content or even content extending the IP.
Fine, I'll take a stab at some numbers. Copyright. Automatic. Limit to 20 years. For more than 20 years each year, a tax of years of copyright, starting at $21, plus years, 20 sales. Thus for year 21, this would be 2 million plus 2% of sales. Year 25 would be 33.5 million, plus 32% of sales. Year 26 would be 64% of sales, and year 27 plus would be pointless. Trademark. Unlimited number of years, but must be filed every year. Some sort of small filing fee per mark, more costly than the government processing. This is also to protect namespace pollution, plus 1% stadit, and of sales on any TMED product. Edit star. The additional tax per product should just be a flat N, maybe even less than 1%. The administrative overhead of having different tax rates outweighs any benefits with my initial thoughts of a cap at 2%. Character and likeness things would all file under the consumer protection of trademark. Patents do not exist anymore. In the modern age, no patent describes the useful art in a way that is useful to anyone practicing that art in the scientific applied engineering fields who should benefit from it, so it is unconstitutional by definition. Discuss and adjust the copyright duration and post free copyright numbers according to real incentive. IMO even 20 years is too long and should be ramped down to more like a decade, but the back end of exponential fee increase should be stretched out to around 30 years total. Also, registration of the copyright should lead to triple actual damages for infringement. Registration would also include filing with the National Library and an association of libraries, an archive copy of the work with is unencumbered by copyright and free of any DRM or other protection mechanisms, to be unsealed after it becomes public domain.
You're listing all the problems, which everyone will readily agree, but what is the solution? Everything else needs to be thrown out and potentially replaced with something else less abusable. I think Netflix should be allowed to fund a big movie and recoup the costs fairly without it being immediately ripped and given away for free, but they shouldn't get to bully people making similar content or even content extending the IP. You actually state almost the exact problem that makes IP law so impossible to do at scale. Like it's easy to distinguish between similar content, extending content versus ripping content. Pure ripping is easy, but step outside of that. When is it similar versus ripping? When is it right to use a DCMA takedown? Is it because a song had a similar 4-note progression? Is it 5 notes? Is it tonality of those notes? The interval, what makes it recognizable? When is a patent the same as another? When is it different? Look at fasteners. There's an insane amount of patents for fasteners. Some are truly novel for very specific purposes. I say it's a special fastener for vibrations in microgravity. Space fastener. Great, that's unique. Oh, and it also works well in 1G HRM. Once a patent is issued, how do you know who it belongs to? The person who made it. Cool, that's great. But let's say he doesn't have the ability to manufacture. So he sells the patent. Now you've got your proper buyers versus trolls. It's easy to say let's get rid of it, and not consider the depth of the problem at hand.
How much do you think the lawyers care what owners think? Read this for some honest takes. They don't even care. Redditro tatter to tense fa. What is destroying musicians is not copyright, but the oligarchy of distribution and lack of artist representation. For food for thought, look up what Ed makes on Spotify per play versus what the average person would, and how much of that goes to the labels and distributors.
Look up what Ed makes on Spotify per play versus what the average person would. I don't know where to look any of this up. Can you just give us the data?